Sergeant, do we have the air conditioning on just to make sure? I mean, I don't know if some people are, they seem to be a little bit warm. Our next sign-in order member is Assembly Member Campos. Please step forward. Again, appreciate your indulgence on trying to keep our comments as to the point and brief as possible. Assemblywoman Campos, please proceed.
Thank you, Mr. Chair and members of the committee. I do want to say that the previous presenter on the bill made a statement about that yes, men do sometimes make more money than women, which will lead me into why this bill is important. AB 1017, a bill that would work towards creating a foundation to ensure pay equity for women across the state of California. It doesn't exclude that men, this can apply to men too, but it really is fundamentally around making sure that we create a strong foundation so that women can be paid according to what their skill set is and what their ability is when they seek a position and the qualifications for that position. Historically, women have been paid less than men in the U.S. Right now, very shocking statistic, Latinas make 44 cents to the white male dollar. African American women make 64 cents, and white women make 78 cents. Even within the women, there is disparity, and women of color continue to make less. Latinas don't even make 50 cents to the dollar. And that is very shocking when I actually continue to say those numbers out of my mouth. In order to enact real changes, employers should not require women to reveal their previous salary. When they apply for a position and they're a candidate, they should actually be looking at their qualifications, not determining that what their previous salaries. That's the beginning of why women never get an opportunity to be equally paid to their male counterparts. AB 1017 addresses pay equity for women in the workplace by prohibiting employers from seeking salary history of potential candidates, prohibiting employers from releasing the salary history of a current or former employee without authorization from the employee. Members, this is an important bill. There are several bills out there going from one house to the other that address this issue. More than 50 years after passage of the Equal Pay Act of 1963, it is clear that the pay gap is unlikely to go away on its own. As policymakers, it is important for us to create the foundation. AB 1017 will help bring historical injustice in pay equity to a standstill. Members, I respectfully ask for your eye on this bill, and I do have witnesses here that will continue to add testimony to this argument.
Thank you, Assemblymember Campos, for bringing this important bill forward. Can you please have your two supporters state their position or go ahead and testify, and then the rest will be add-ons.
Okay.
Hello, Mr. Chair and members of the committee. My name is Aileen Rizzo, and I'd like to share with you my story that's directly linked to solely using prior pay. My name is Aileen Rizzo, and I'm the mother of 3 daughters, and I'm the sole breadwinner of my household. I've worked in math education for approximately 19 years. I have 2 master's degrees, and so I kind of dismiss a lot of these excuses for paying women low wages. I studied in the STEM field, I have high education, and yet I'm still being faced with unequal pay. I found out in July of 2012, my 4th year with the County Office of Fresno Education, under the leadership of Jim Iovino, that one of my colleagues who had just signed his first contract signed at a salary step that would grant him thousands more than I was making and nearly $20,000 more than what I was going to be making on my first contract. I thought this made no sense for 3 important reasons. I had more experience than he did, more education, and more seniority. As the other males showed their salaries, it quickly became apparent that as the only full-time female in the math department, I was the only one who, when hired, was placed at the lowest point of the salary scale. I was humiliated, embarrassed, and ashamed, and the next week I spoke to the HR administrator. She explained that the institution solely used prior pay to base my salary. I explained how such policy allowed for discrimination and left mostly women and women of color with the burden of carrying on the past of low wages, that we could never break that barrier. It perpetuated the wage gap, and either they did not believe that there was a wage gap or that this was definitely perpetuating it. I wish I could tell you that after the conversation, everything was set right and the policy was revised, but that is far from the journey I've taken so far. I waited for a month for a formal reply, and I received a letter that in essence said, "We know you feel slighted, but we're standing by what we're paying you." When I decided to get a lawyer, I had no idea how long it would take. And I had no idea how much we would have to invest as a family, emotionally and financially. It took 6 months alone for me to get a right to sue from the Department of Education, which is necessary when you try to sue a state entity. And if I win summary judgment, which the hearing is in August, my protracted trial date is not till January of 2016. That's how long I've been waiting to get equal pay. My parents sacrificed so that I could be the first to graduate from college. I paid the same tuition as the male around me, but I know that statistics show that when a woman leaves college and enters the working arena, she's paid less right at the start. Many would say that we do not need more laws, but I've been grateful for the laws that we've had. They've given me at least a voice and a chance to fight for equal pay. No one would prefer the path of a lawsuit. It's a drain standing up to an institution that has deeper pockets and no urgency to resolve this matter at all. Many women like me work years without knowing that the man that sits next to them is taking more money home to his family. This definitely affects more than just me and many women. It affects our families. My story is not over. Every day I go to work and I expose myself to continuous discrimination. When I am praised for work that I do well, when there are requests for my work because I'm highly skilled to do it, when I get statewide recognition for my expertise, all of that is tainted. Because the reality is that my employer chooses to continually pay me less than all of my male counterparts, and I can never regain what I've lost in my pay and retirement. I strongly urge your I vote.
Thank you so much for your story. Next witness.
Hi, I'm Shannon Smith Crowley, representing the American Association of University Women for California, but I'm personally putting my face to this. And I also have to say, I know I have a certain privilege as a white woman, and like Aileen, very highly educated. I'm a lawyer with a master's in health administration. Years ago, I took a few years out of the job market to raise my small children. And when I went back, it was a little difficult to re-enter the job market. So to go into an industry in which I had my eye on, I was willing, in order to get my foot in the door, to take on the initial salary. The company had a really excellent reputation for training contract negotiators, and they also had a reputation for very low pay. So it was a target for recruiters, and I got a recruiter call a week. So I finally found one job that really intrigued me, interviewed, got it, and I thought, finally, I'm starting to make what I'm worth. Well, not so fast. I had to fill out the initial job paperwork before I started the job. I got an irate call on a weekend from the woman who hired me, saying, basically, how could you have made such a low salary and you're making basically double now? So the system was set up. I think even though she would have liked to have continued to hire me, it didn't fit within the structure, and she actually rescinded the job offer. So again, I'm somebody who has all the tools. I was a proven contract negotiator that brought in tens of millions of dollars a year to my company, and I still couldn't get the company to work with me. So actually, what this reminded me of was kind of the medieval feudal system. When you're born a peasant, you're always going to be a peasant. You can't rise. And I think about how many people come to the United States, as a land of opportunity, because no matter where you started, that you're going to be able to rise based on your merit. And if you have this perpetual system, how do you ever get out of that? So I am so grateful for Assemblymember Campos to introduce this bill. I think this is a perfect complement to the other equal pay bills, and I hope sincerely that you vote for this and continue to support this. Thank you.
Okay, thank you. Any more supporters, add-ons?
Good morning, Chairman, and thank you for this opportunity to briefly add on our support. My name is Jennifer Reich, and I'm here with Equal Rights Advocates, on behalf of Equal Rights Advocates, to strongly support AB 1017. I would just add that, as a complement to Senator Jackson's bill, SB 358, which will strengthen our equal pay law, this bill will help to address one of the many contributors to the persistent gender wage gap. And really what this bill is about is trying to, in a small but significant way, level the playing field when it comes to transparency and access to information that currently is really uneven when it comes to salary negotiation at the time of hire. Employers know what they pay their employees, and they know what they can afford to pay, and they have access to the information that they need in order to set a reasonable salary range. Prospective employees, know what they've made in the past, but they don't necessarily have access to the information about that employer's payroll, and they don't, and they're not going to be able to negotiate on any kind of level playing field if they are tied to wages that may very well be impacted negatively by the fact that they are a woman or a woman of color or other minority, and therefore have suffered over their lifetimes, many different forms of wage discrimination. This bill is not going to be a heavy lift. It doesn't make a huge demand on employers, but what it does do is it helps to promote transparency, and it helps to, again, give women the tools that they need to really be able to fairly and negotiate with an employer about their salaries, and for employers to make sure that they're not basing their salary decisions or hiring decisions on prospective candidates' prior earnings. So we strongly urge your aye vote. Thank you very much.
Thank you. I appreciate the comments. Are there any other supporters? Please step forward. Okay, one more. And if we could have the dais clear so we could have, the table clear so we could have other.
Tia Orr on behalf of the Service Employees International Union. We're in strong support.
Thank you. Okay, great. We could have the opposition step forward, and we'll clear the table so we can have them sit in front. Please have people that will testify, and then the rest can add on.
Good morning, Mr. Chair and committee members. Jennifer Brewer on behalf of the California Chamber of Commerce, and we are opposed to AB 1017. In a prior committee hearing with one of the members of this committee, I testified and stated that the California Chamber of Commerce believes that all employees should be paid equally for the job that they are performing if they are substantially similar job duties in substantially similar situation. And we agree with that, and we are actually in support of Senator Jackson's bill that is demanding that employees be paid equal pay for equal work. But that is what ultimately the focus should be on, is what is the end compensation that an employee is being paid and offered with regards to the job duties they are performing. This bill prohibits an employer from asking an applicant what their salary information is or their compensation or benefits have been at their prior employer, which is a relevant issue and inquiry for an employer who is actually could be benefiting the employee in the sense that they're looking to increase that amount in order to entice the employee to come and work for them. It's a relevant consideration. Whether or not the employee is actually paid the same amount for the same work opposed to a man in the same position should be a consideration, and that's why we're supporting Senator Jackson's bill to specify that that should be the case, that they get equal pay for equal work. But precluding an employer from asking about it at the outset denies them the opportunity to inquire into relevant information. Because it's a part of the labor code, an employer could be sued under the Private Attorney General Act for inquiring into an employee's prior compensation and prior benefits, even though at the end of the day there is no injury to the employee because they offer the same, if not better, compensation than when a male employee is making in that job duty. So we are subjecting employers to civil litigation simply because they're asking about an applicant's prior job history, even though there's no ultimate harm to the employee at the end of the day. They're making the same that the male employee is working in that same job position. Additionally, it's in a labor code section that exposes them to criminal prosecution. So this bill would say that if you ask an applicant verbally or in writing what their prior compensation and benefits are, you could be subject to criminal prosecution for a misdemeanor. So employers are being subject to criminal prosecution, civil prosecution, for asking an applicant about salary information, even though at the end of the day, the employer may offer them the same compensation as a male is making or better and offer them a better benefit package. We don't see the reason for or need for this bill if at the end of the day we're saying that an employer has to provide equal pay for the equal job. And from our perspective, it's just opening employers up to civil litigation and actually criminal prosecution as well. And for those reasons, we're opposed.
Mr. Chair, members, Chris McKaylee on behalf of the Civil Justice Association of California. Like my colleague from the Cal Chamber, we actually shared an earlier statement by Ms. Campos in which she said people should be paid based upon their skill set and qualifications. We concur, and that's why, like the Cal Chamber, we worked very diligently over the last few months to eventually go from opposition to support of Senator Jackson's SB 358. I would draw attention, if you look at your bill, to page 2, line 18. All the discussion today has been on compensation, and I would just note that the bill actually includes benefits as well. And it should be noted that clearly an employee who has, for example, been in a 401k or had health, dental, vision, whether or not that employer offers that, that's obviously not based on sex. In other words, if you offer vision care, it's for all employees, or health care, it's for all employees. And as Ms. Barrera noted, again, these are subject to PAGA. Although it's been in existence for 10 years, we have data from the last 8 years. We've seen a 400% increase since it went into effect in 2005, the number of lawsuits that are filed on an annual basis under the Private Attorney General Act. For those reasons, we are opposed.
Thank you.
Mr. Chair and members.
Okay, we're going to have others add on. Go ahead.
Mr. Chair and members, Javier Gonzalez here on behalf of the California Restaurant Association in opposition.
Julianne Broyles here on behalf of the California Employment Law Council, also in opposition.
Dean Hutchings with the California Grocers Association in opposition.
Tim Schmelzer with Wine Institute, opposition.
And Nicole Rice, California Manufacturers and Technology Association, also opposed.
Braden Obrowski on behalf of California Association of Health Services at Home in opposition. Thank you.
Thank you. Do we have any questions from members? Senator Mitchell, Jackson, maybe.
My question is for the chamber. You state that that the employer, based on and if this bill were to become law, would no longer be able to ask this valuable information. Then how do we prevent the scenarios that I have experienced, that we heard in testimony from the proponents, from happening, that if the employer has this information, that they then develop policies that limit your ability to earn the salary that the job warrants? The legislature has a policy that you can't earn more than 10% as you bump from position to position. So how do you prevent that from happening, which ultimately gets to the point that you support, apparently, in the Jackson bill in terms of equal pay for equal work?
It's a delicate balance. Okay, to kind of go off of, I'm trying to understand your question. At the end of the day, they can't pay under Senator Jackson's bill in current law. They should not be able to pay a different compensation based solely upon gender, right? If that job is paying X amount of dollars, then that should be the same compensation whether you're female or male. Okay.
Apples and oranges. So let's just say, what would prevent an employer from using the information, from paying a woman, in this case, or a man or anybody, the value of the job at hand? What prevents them from having those policies once they have the information about previous salary?
So taking gender out of it, again, if it's the same compensation no matter what for that job duty, then that's going to be the compensation. If it's too low, I would suggest that the market will correct that, right? If you're an employer that is offering a compensation that is way too low, employees are going to be working for you for a limited amount of time. That happens in a lot of our industries. I would utilize the tech industry as one of the examples where employees can be picked up in a second if their employer is offering a compensation package that's too low. And we say compensation package, we're talking about benefits as well, because that is certainly an interesting and an important part of the compensation package for a lot of employees. So I would suggest that if an employer is trying to low base their pay compensation for employees, the market's going to take care of it.
Well, in the examples we were given, that wasn't the case. A salary was posted, a person applied, was given a thumbs up, and then when the information came about your previous salary, right, assumptions were made, right, and therefore she wasn't hired. So my point is, if employers continue to have that information, what prohibits them from having these policies like the legislature where you can't earn more than 10%? See what I'm saying?
Yes.
Because that has nothing to do with the value of the job. You just can't make more than 10% from your previous employer.
So that issue, from my understanding, is already protected under existing law with regards to the Fair Employment and Housing Act, which specifies that you can't discriminate against gender. And the EEOC, which the analysis points out, has already come out with the position that if you base compensation solely on prior history, prior salary history, it's unlawful. So that is already existing law. That's what the EEOC has already put out an opinion. And that's something that we're willing to talk about with the author's office and that we've had the discussion with. If that is the issue, that you want to preclude somebody from basing compensation solely on prior salary history, that's certainly something that we would be willing to discuss as a part of an amendment to this bill to say that an employer shouldn't base their compensation decisions solely on prior salary history. But that's not always the consideration, and obviously skill set, qualifications, experience, education, all of that comes into play as well.
Thank you.
Thank you, Senator Jackson.
Thank you. Very briefly, I think this bill addresses the fact of what is going on, is that women historically, when they get out of their educational experience, even in women who are highly educated, and as we see here, mom who has a full-time job with 3 little ones, right here, this is evidence right here that they are, and they're all little and wonderful, and I have to tip my hat to you. I can't imagine doing all that. I stopped at 1 because I figured I just couldn't do all that. But yeah, so but the point is that this bill prohibits an employer from asking that. Not if an employee wants to provide that information as part of a negotiation, because truly, when women get out of college, they are historically paid less, and they never catch up. And I think if we focus this bill on that fact, it will help equalize the playing field. And I would just suggest to my good friends at the Chamber, with whom I have been working and have a deep appreciation for their willingness to address this issue, that this is not an onerous burden on an employer. Just simply, and I think our own House, our own legislature should be addressing this issue as well. It isn't necessarily going to catch just women, but the reality, the fact is that because women are paid less when they get out of college, women are ensnared in this trap and should not be. And I would be very interested when you say also solely, that you can't be solely discriminated. If that can be a factor for this young woman here who has demonstrated extraordinary talent, she may or may not be able to overcome it. But why should we be in that position? Why should we have to be fighting all the time for that sort of equal recognition? And so with that, I want to thank you for bringing this bill, and again, recognizing that there is the possibility for discussion if the employee seeks to have it. I am concerned, however, I would hate to see this as a criminal matter. And if this is indeed potentially relegating an employer to a criminal prosecution, I civilly nail them, whatever, but I just think right now, if you would just take a look at that, I'm still going to support the bill, but I think that might be a tad more than is necessary. If you could respond to that in your close, I'd love to hear it, but I will move the bill.
Okay, Senator Jackson has moved the bill. I would just like to make a few comments, if I may. First of all, let me say that I think one of the most important issues that we've taken up as a legislative body this year has been income equality, and I want to salute Senator Jackson for being the champion of this legislation that is bipartisan and is really the end product. We're going to ensure that women are going to be paid commensurate with their male counterparts and vice versa. I am concerned, as Senator Jackson is, that we're going to have a criminal allegation, prosecution, he said, she said. But in the end, assuming that Senator Jackson's bill becomes signed into law, which I certainly hope that it does, I don't see why you could not find out what market rates are for particular employment classes. As an example, I mean, I have very little turnover in my pharmacies because I treat my employees very, very well. In fact, I probably haven't had a turnover of a pharmacy tech in probably 5 or 6 years. And sometimes you like to look at your prospective employees' histories where they were employed to find out really what's the market rate, for techs. Am I paying my techs market rates? And I assume that I am because I have such little turnover. In fact, I've discovered that I pay usually more than the market rate because I want to make sure that these highly qualified people stay with me. So the point I'm trying to make is that there's actually several legitimate non-discriminatory reasons why an employer will seek this information regarding the prior compensation of an applicant, and certainly those that abuse that. It's my understanding that there's already existing law that you cannot base the compensation on based on a prior employment history. And then I will differ with my colleague from Santa Barbara that this does create yet another avenue for litigation against employers in a state that has probably the most litigation against employers of any other state. I'd opine that was probably true. This is, again, just giving another opportunity to sue your boss, even though there was no harm done, even though an employer may have examined your prior employment history, but ultimately hired you because you had great qualifications and gave you the higher income that is commensurate with market conditions and certainly commensurate with what a male counterpart would make. So for those reasons, it's going to be very difficult for me to support the bill today. But with that, unless there's any other comments, Senator Leno.
Thank you. In full support of the bill for all the reasons stated and the compelling testimony that we have heard. And can you please help me? The first woman who testified, she's been with us in this committee hearing before, always articulate. I should know her name.
That's Eileen Rizzo.
Ms. Rizzo. Thank you, Ms. Rizzo, for your testimony, not just today, but in the past as well. An analogy has come to my mind. I don't know if it's going to be beneficial to anybody else in the room, but when symphony orchestras have tryouts, auditions, they struggle to diversify, and because it's traditionally male, white, but there's a lot of talent out there, and auditions are held behind screens. So you want to screen out historical reasons for discrimination. You just want to hear the music, hear the quality of the applicant, and screen out the other information. I think this is something we want to screen out, again, for the reasons already described. If the policy question before us is, how do we ensure that applicants are hired based upon qualifications and not on other extraneous details, I think this bill will only be beneficial. Of course, as an employer myself, concerned about liability concerns. I just wanted to ask, and maybe from the ERA you can help me with this, we already prohibit an employer to ask about an applicant's age. Would this be any different? Would liability be greater if we prohibit this and a question is wrongly asked, any different from when an employer could potentially wrongly ask, what's your age? Which is not allowed, right?
Right, nor do we permit asking about marital status or about a number of other protected factors. And I think the analogy to the blind audition process is a good one. You know, gender may be a factor in setting salary in a way that is not the product of intentional, conscious discrimination on the part of the employer, but merely by carrying forward the salary that that person was making in her prior job, or as was pointed out by Ms. Smith-Crowley, who testified on behalf of the AAUW, you know, there's also the fact that women are more likely than men to take time off from the workforce entirely for some time period in order to take care of family. That is still something that is disproportionately, you know, held by women, a burden that's held by women, and that impacts their ability to go back into the workforce and then get paid the salary that they deserve, and that job, you know, deserves to be paid when they come back in. And so under the Private Attorney General's Act, you know, you have to be an aggrieved employee in order to bring a claim under that law. And there are many different provisions of the Labor Code that can be enforced through the PAGA. And this would be no more and no less onerous than any of those other provisions, including the minimum wage. Correct. It would not be treated differently in that respect. So the answer to that question. Thank you.
Thank you.
Okay, thank you so much. Do we have any more questions? We have a motion yet?
Just to throw out one last thought that came to mind. In light of the testimony that Ms. Rizzo has shared with us today, I think this bill will have another benefit. It will benefit male applicants. It will benefit male applicants because if your employer could do to other female applicants what your employer has done to you, then an employer knows, oh, I can get the same talent. I can even get someone more talented with better credentials and pay her less. If I can find out that I can get that, that's a disadvantage for the male applicants. So I think it's going to benefit everybody.
Great. All right, so we do have a motion. Thank you, Senator Member Campos, for bringing this important measure forward. I do support the bill. I think it's a great bill. I do believe it will be leveling the playing field, allowing more opportunities for people to apply without having to be worried about not getting paid adequately. As a father of three girls, I support. I see where this could benefit me and my family personally, and you know, I think it's you know, this disproportionately impacts women of color, which is disappointing. But I appreciate the bill, and thank you again for bringing it forward. And Madam Secretary, please call the roll. Oh, you have to close still?
There was a lot more discussion than I thought.
Okay, please.
First of all, thank you, and I want to address the one question regarding Cal Chamber and some of the things that they brought up. I always welcome the opportunity to sit down with the opponents. If the issue is the criminal part that was never brought to my attention by the opponents, more than willing to sit down and have a conversation with that. So I wanted to just state that. But I really appreciate all the comments from this committee, the opportunity to hear the concerns you brought up, and also the supportive points that you brought up, because I think that what I've learned in this particular committee is that there is robust dialogue. And I think as I continue to move forward, whether it's with this policy or policies around this issue, to make sure that we continue to elevate women in California, and hopefully the nation will follow us around our policies, that's a proven fact, that women will be able to be equal, and the statistics that I brought up earlier will no longer be statistics anymore. and that mothers, I really appreciate Miss Russo bringing her children, because I was a mother here, like Miss Mitchell at one time, where we brought our babies and they grew up in this house. And I always say the profession that I pick, the reason why I'm equal to my male counterparts is because we all make the same salary because of the institution's policies. But that's not the same out in the private sector. And it is, and the question always is, if not now, and I'm not even going to ask when, because there shouldn't be when, it is now. It's time for us as women in California to be bold enough to say, and as policymakers to say, it's time for women and women of color to be making what they're worth. Not on this scale that says, you know, you made 50,000, but this position, and these are low numbers, but I'll be respectful, and the position pays 80. Well, let me see. Maybe I can negotiate in the middle, and I'll give you 10,000. Well, that's not good enough if her qualifications are more than that 10,000. That should not be a factor in determining why we hire a woman for that position. So I respectfully ask for your aye vote.
Great. Madam Secretary, please call the roll.
The motion is due pass to appropriations. Mendoza?
Aye.
Mendoza, aye. Stone?
No.
Stone, no. Jackson?
Aye.
Jackson, aye. Leno?
Aye.
Leno, aye. Mitchell?
Aye.
Mitchell, aye.
Okay, 4-1, your bill is out.